Hello, Stephanie Joy with All Things Social Security. We had a Q&A with a short little clip discussion on a particular topic. So I'm going to attach it for you here. It might be something that you're interested in if you clicked on this header. And following that, we're going to go through it a little bit more. So just wanted to give you the heads up. This is where it started from, and then we'll have the bigger discussion right after. All right, chat with you later. Bye-bye. Carolina Bread. Hi, Carolina. Had my ALJ yesterday. All of my 23 minutes. Yeah, they like it nice and short. That's not unusual. Lawyer asked 3 questions of me. ALJ asked me no questions, but gave 3 hypos to VE. Attorney challenged all. VE conceded no jobs. Hearing over. Outcome probability? Can't say. VE conceded no jobs, only on the one hypothetical that was put up by your attorney. You see what I'm saying? So the ones that the judge proposed, there were plenty of jobs. When your attorney said, but what about this? What about this? What about this? He added things that the judge did not find important to add. Now, does that mean the judge found them not important to add because he doesn't think he actually knew those pieces of evidence were in the file and found them not to be of much worth to find that that limitation is true that your attorney proposed on those additional VE hypotheticals? Or did he never even see them because, they're skimming a case, and now that your attorney brought them up, he can think about them and say, oh, there is some evidence in there. My attorney advisor didn't point this out or whatever. And therefore, did your attorney's addition give him some more food for thought that he will think about, which I'm sure he will after the hearing. He might still disregard it, but he might disregard the extent to which your attorney categorized those evidence impairments as to what kind of task functioning they'd limit. He might not agree with that. And therefore, then he doesn't have to go with the VE's statement that, yes, there would be no jobs if that was true, Mr. Attorney. If all those things are found to be true, Mr. Attorney, those jobs, there would be no jobs. And then the underlying answer is that your guy wins. But do you see what I'm saying? So I can't say that it's there's a probability one way or another. It's really what the judge is going to do. I never like it when a judge gives, the only hypotheticals the judge gives is there are jobs. I don't find that. What if if your attorney never said anything, and some people have attorneys that just sit there because they're not really doing their job, your judge would probably have carved himself into a intentional box where he has to deny you. So why would a judge take the risk of doing that by giving all negative hypotheticals if he went in there? I'm just giving you kind of like the logical inference maybe, but your attorney might have changed his mind, and that's our job. It's very hard to change a judge's mind once they already kind of have it. They're attorney advisors. They had all been over this case, but sometimes it happens. But if nothing else, your attorney has prepared the case, and this is very important for appeal to AC, and that's part of the job. It's not just winning then, it's knowing that you have to cover your client's butt if your client has to appeal. So it's kind of like a things behind the scenes. We go, what do you do behind the scenes? Nothing that we can actually explain, but that's one of the things he was doing when he was doing this, was setting up for plan B if this judge was going to continue with plan A, the judge's plan A. So anyway, just one way to look at it. I wasn't there, so I can't say for sure, but that would be some of the things I would think maybe happened just by those minimal facts we gave. Hey, so if the subject matter of the video you just listened to is of interest and you want more on it, stay tuned. Here's another one about the same topic, but a little bit different. Bye now. Hey, so in a recent video about ALJ hearings, we are going over the part of the hearing where the vocational expert is going to be asked hypotheticals. I had a hearing today. It was fabulous, better than I expected. I expected okay. I hoped for okay. I was hopeful for okay, but it was better than okay. Anyway, and it became clear to me at the hearing that it was going to be a better okay because, and this is not typical, the ALJ asked one hypothetical, one. So there was no question, by and large, as to what RFC he's going to be applying to my client, because he only asked the vocational expert about one residual functional capacity assessment with all the limitations described within. So, and that one included things that I already know vocationally provide for no jobs. That would be being off task more than 20% of a day, missing more than 2 days a month from work due to medical symptoms, amongst the other, because when you go to the beginning of the hypothetical, they're talking about sedentary or light or whatever. Then they're talking about, can the person be around hazardous machinery? Can they balance on scaffolds? Do they need a sit-stand option? How much can they use their hands? So while I might not have agreed with all of the other parts of the hypothetical, all the limitations. I thought some were easier than others, but I understood kind of where they were coming from because some might be improving in the near future. But anyway, so when I heard the very clearly disabling limitations added in there that I already know from years of doing this would be disabled, I knew it was good. So when you have one hypothetical, and again, this is more rare because I think oftentimes the judge isn't sure whether he's going to deny or award because they have to get through the rest of the evidence, which includes the testimony, which hasn't happened yet. And I think also they want to, once they hear the testimony, really go back and, you heard a couple of things. Is there anything in the record that supports that or refutes that? And they can come to a final determination for cases that might be close. And there is that multiple hypothetical situation, which is typical because that way they can include what they perceive as being the possible RFCs that might apply to the claimant. So when there's only one, it can be very bad because there are jobs that the vocational expert indicates are doable with that RFC. And then if the judge doesn't continue to go on and ask more limited hypotheticals after that, that's when the lawyer has to jump in and make sure those get in. Or the claimant if you're unrepresented. So you got to figure out how to do that. But if there's one and it is all good and there's no other options, that's when you're almost at the point of singing. I always say I want to see the decision in writing, and that's true. But sometimes the judge will also put right on the record that I am deciding that you are disabled, or I'm giving you a favorable award, and then you pretty much know you're in. So anyway, one hypothetical, it usually spells the story. And so you kind of know what the result is going to be before you get the decision. Anyway, enough on that. It was a good day. Let's hope tomorrow is as good as today. All right, bye now. Hello again. I hope you enjoyed the video. I hope it was helpful, if not just a little bit informative. In the event you have a Social Security question you want addressed, please feel free to make a comment below and ask the question, even if nothing to do with this particular video. And just a quick, again, reminder, we have our daily video shares and tips around noon every day of the week. And on Wednesdays at 1 p.m. Eastern Standard Time, we have our live Q&A session where you can come in live and enter your questions in the chat. And we all pretty much have a good time for an hour or two. I look forward to seeing you there, hopefully. And lastly, don't forget about our benefactor memberships. They're very reasonably priced. The first one is very nominal, and you get a few perks, but on a bigger scale, it contributes to us being able to fulfill a mission of assisting certain people with representation that would otherwise not be able to get it. We look forward to continuing to do that, and so far it's working out like the bomb. So thank you for being here. I appreciate it. Bye-bye now.